Yes, ma'am. Yes.
Good morning, everyone. Good morning, everyone. I, Pooja Adnani, welcomes you all on behalf of Postgraduate Teaching Department of Law, Rashasant Tukrolji Maharaj, Nagpur University. In today's webinar session on how to argue a writ petition in the High Court by Advocate Dorman Dalal sir. Before starting, here are some general instructions for the participants. At the end, there will be doubts clearing session wherein you all can type in your questions in the chat box. Secondly, a link for the feedback form will be posted in the chat box. Please note that participants will receive their respective e-certificates only after submission of feedback forms. Now I request our panel Ms. Dipali Mankar ma'am, Assistant Professor, PG Teaching Department of Law, RTMNU, for setting the theme of the webinar. Over to you, ma'am.
Thank you, Pooja. A very good morning to all. I welcome you all in this webinar for which theme is how to Dipali, madam, you are not audible. Okay, ma'am. Just a minute. A very good morning to all. I welcome you all in this webinar for which theme is how to argue a writ petition. Rights are nothing but claims and interests which are recognized and law. Very refined existence and enforcement through judiciary. Right may be or can be through the in the and security. This due protect of individual even against the or makes the disciplinary ordinary matters protectionality. Only important, but to avail the remedy at the appropriate is equally essential and relevant, and their arguments that have been as a remedy become significant in order to succeed to convince the court for grant of relief. The important technicalities and intricacies of the skills of arguments for writ petition is something that can be understood only with experience. Therefore, to enlighten us on, we have with us Mr. Dorman Dalal, sir. Welcome to you, sir.
Thank you, ma'am. Now I request Dr. Payal Thaure, ma'am, Head of PG Teaching Department, to deliver the opening address. Over to you, ma'am.
Respected Advocate Dorman, respected my dear colleagues from the department and all dear participants, again, a very pleasant morning to all of you. This has been our 8th webinar from the 10 webinar series. And today also we are going to have one of the very important topic, that is how to argue a writ petition in the High Court. The idea behind choosing this particular topic for conducting the webinar was certainly to develop the skill amongst our participants and students, that how they can pursue their career or how they can enter in this profession wherein they can be a successful lawyer by knowing the skills and the techniques of how to argue the writ petition. I mean, today we can very well say that if we refer to Carl Levelin's version of understanding how the law has been made, then he has propounded this concept that law is something which is not made by the judges, but it is something which is made by the lawyers. Unless the lawyer makes that argument in the court of law, unless the lawyer makes that prayer, or has that prayer in his petition, probably the judiciary will not be able to give any judgment on that aspect. So as a lawyer, it becomes very, very important to have those points, to have those interpretation and to have those aspects for consideration about a particular point of law in the court. Unless you have that, the judges cannot move ahead by, like, having the law or having a judgment, or what we can say, a precedent about it. And considering this in mind, we firmly believe that somewhere we have to go beyond books as well. Now, what we learn in our LLB and in LLM, somewhere we feel that after certain point we get within that limitation of knowing only about the book. But when you go to the court and when you start practicing, there are certain requirements which are probably not covered under the academic syllabus. And that is why we wanted to have this webinar. And I'm very sure that the insights provided by our honorable resource person for today, Advocate Dorman Dalal, will certainly help our participant to in enhancing their learning skills about how to argue a writ petition in the High Court. So once again, I extend my gratitude to Dorman for graciously accepting our invitation and for being with us. And I'm looking forward for your talk, Dorman. Thank you so much.
Thank you so much, ma'am, for a very lovely introduction. It's a pleasure to be here. I would have liked to be there in person because the last time I came to Nagpur was almost 12 years ago. I love the Nagpur bench more than anything else because it's a beautiful structure modeled on the Supreme Court to some extent. So today's lecture is going to be it's a very important topic because
Dorman, sorry to interrupt. Just give us 1 minute so that we can introduce our participant
Yes,
about
sorry.
like today's resource person.
Right.
So yeah, over to you, Pooja, and then we'll continue with your lectures.
Okay. Dorman Dalal, sir, is a practicing advocate at Bombay High Court. He has been practicing on the appellant and original side of the High Court since 2013. He is also an arbitrator and mediator. He completed his schooling from St. Mary's School, Pune in 2004 and thereafter completed his junior college from Ferguson College, Pune. In 2006, he joined DES Law and completed his graduation in 2011. After his graduation, he did his post-graduation LLM from the Department of Law, University of Pune, and completed his dissertation under the guidance of Dr. T.S.N. Sastry on the use of the veto power by the United National Security Council and its impact on human rights. He completed his LLM in 2013 and also simultaneously passed the National Eligibility Test in 2013. After his post-graduation, he had the good fortune of working in the chambers of Mr. Anil V. Anturkar, Senior Counsel, Bombay High Court from 2013 to 16, and assisted his senior in several high-stake matters and landmark cases. In 2016, he started independent practice and currently practices predominantly in the Bombay High Court and the National Company Law Tribunal, Mumbai. His areas of practice include civil and commercial dispute pertaining to constitutional law, the Insolvency and Bankruptcy Code, the Arbitration and Conciliation Act, land acquisition and revenue laws, cooperative society and housing laws such as MOFA, RERA, etc., MRTP Act, matters pertaining to environmental laws, family laws, etc. He was also a part of High Court Legal Service Committee from February 2017 to Jan 19 and has appeared in several pro bono matters. In January 19, he completed his certification course in international commercial mediation from the Indian Institute of Arbitration and Mediation, Kochi, and is impaneled as a Grade B mediator with the said institute. He has also completed his certification course in mediation advocacy in 19 from the said institute. He frequently appointed by the Honorable Bombay High Court as an arbitrator for commercial disputes and is also impaneled on ODR platforms such as ADRES Now. He also regularly writes columns and articles for Live Law, All India Reporter, The Leaflet, and has also written for Bar and Bench for SSC blog. Apart from law, his other subjects of interest include international relations and contemporary history. It's a really privilege to have you, sir, here. Now I request you, sir, to give us some insights and enlighten us on how to argue a writ petition in the High Court. Over to you, sir.
Thank you so much for the introduction. It also makes me realize how old I've become after all these years. Anyway, coming back to what I was saying, I would have loved to be in person and have this lecture rather than a webinar because it's a very interactive session. So I have completed 10 years of practice, and this topic is very appealing to me because I'm not here today to give you a lecture per se in the conventional sense. I'm just going to tell you what I have learned and how I have, along the way, through mistakes, through learning experiences, come to a certain point where I feel that, look, this is the kind of journey which you should take while arguing a writ petition. There is no right and wrong to anything. These tips which I'm going to give are not yardsticks of any sort. Any other person would give you a completely different perspective on this. But this is what I have learned, and this is what I feel like sharing today. If we could share the PowerPoint presentation, then I could just start with a basic introduction on the topic. Could someone share the PPT, please?
We made you co-host, so you also can share
The
your.
sharing option is not activated.
Yeah, Abhi, please make a presenter.
Yeah, now it is. Thank you. So the topic today is how to argue a writ petition in the High Court. I am going to confine it primarily to the Bombay High Court because most of you, I believe, are from Maharashtra, subject to correction. But in any case, the commonality in most high courts will enable you to pick up certain important points from here. Now, what happens is that your first question obviously will be that before arguing a matter, I should know how to draft a matter. But in practice and in reality, that seldom happens. You join a senior, very often the senior will not trust you with a brief. You're too new, you're too junior, the client doesn't know you. To get that confidence, what the senior will first start making you do is start mentioning a matter. Now, what is mentioning a matter? Early morning, the High Court starts at 10:30. Your computer generated date, CMIS date, is somewhere at the end of April. There is an urgency in the matter. So therefore, your senior says, go mention a matter at 10:30 in the morning and tell the court that this is the urgency. I remember my first mentioning, I couldn't utter 2 straight sentences from my mouth because I was so nervous. But that's the way you basically start. So you start with mentioning a matter, you start with adjourning a matter. Supposing your senior is busy in another court, you are the bakra which has to go ahead and adjourn that matter. The judge may adjourn it, the judge may in fact get irritated with you. You may ask for a passover or a keepback saying my senior will come in some time. Judge may give it, may not give it. But this is how you start in the profession, basically, particularly in the High Court. And in that process, when you are adjourning matters, when you are sitting there assisting your senior, you are looking, you're waiting, you're watching, but you're also learning. You're learning how everybody argues, everybody handles things. So this is how you basically start. And there may be a fundamental flaw in this process because, I mean, if you are going to argue a matter, you should know how to first draft a matter. But in practice, it really doesn't work this way. It works the other way around. And this is why it's important to know how to argue a matter in order to know how to draft a matter. Now, there are 2 types of briefs. We have a petitioner brief and we have a respondent brief. A petitioner brief, in my submission, is read very differently from a respondent brief. I personally take about 4 to 6 hours to read the matter for the first time. A lot of people feel that is absolutely ridiculous because you don't have that kind of time. And as you progress, as your practice progresses, you genuinely don't have that time. But that first reading is very, very important. A lot of seniors will tell you that you go to the impugned order, means the order that you're challenging. What is your challenge in the petition? You first read that. And after you read that, then you go to everything else. I don't agree with that way of reading a brief. I would feel that you need to first have a complete mastery over the facts. You need to know what the facts are. What I do is then I make detailed notes. I make a long note and I make a short note. My long note initially, when I started off, used to go into 13 and 14 pages, and then I realized that I am not going to be able to use that when I'm arguing a matter because I'll be all over the place. So then I developed a concept of short notes where everything will be put in one page. And I color coded things. For example, you have post-its. So in my head, an orange flag or a red flag would be very important. So those are important pages of the petition. Now, if you're using an iPad nowadays, people use an iPad. If you use liquid text, you can then mark it according to different color combinations, depending on what you're comfortable with. So in my mind, my brain tunes me to look at bright colors. So that is what I'm drawn to first. So then an orange flag or a red mark on a pen on a paper would immediately draw my attention to that page. So that's how I developed what I felt was important no matter what I felt was not. But also thoroughly reading the pleadings. Now what happens is that if today your senior gives you a brief, you have not drafted that matter. Sometimes the matter is drafted well, may be drafted by your senior, may not be. Sometimes it's drafted badly. You don't know. But you need to know how the matter is drafted. So your pleadings, what the petitioner's case is, what happened next, how the situation happened, what problem happened. That has to be very, very clear. Now, a lot of people, for example, where I practice in Mumbai, the Bombay bench is very liberal with pleadings. But the Nagpur bench has always traditionally been very strict on pleading. Has been very, very clear that if you don't have a pleading in the writ petition, I will not grant you permission to amend the petition, and you argue based on what you said. An Aurangabad judge would take it in, it'll be a mixed view to certain things. But it's always important to understand what your case is all about, how you have pleaded a particular point, what your grounds are, what your prayers are, what have you asked for, what is your principal ground, what do you want. And then after you're done with all that, then you read the order that you're challenging. Because if you start with the impugned order or the order that you're challenging first, then your mind is tuned to think only around that. And therefore, it is important to look at what the facts are, then look at the impugned order, then see how you can advance your case. And once you're done with that, put down your questions, have a discussion with the client. A lot of times you have to also understand that your client will never be telling you the complete truth. It's human nature. It's the way it is. So you have to understand, you have to ask certain questions which are relevant, which you think the judge will ask you, and which you think are common sense questions, but may not be so easy to understand or even answer. So after you have that discussion, then you say that, okay, now I am prepared. I am prepared with everything. I have read the petitioner's brief. But now what happens if you're a respondent? If you're a respondent, I would say that don't follow what you do when you read a petitioner's brief. You start reading the prayer clause. What is the challenge that the petitioner has put forth? You read the impugned order. What is he challenging? What is wrong in that order? What are the grounds that he has raised? And always remember that as a respondent, that you have not controlled the narration of facts. It is not your story. You are there to poke holes in that story. You are there to destroy that argument. You are not there to build on it. So as a respondent, you are not in control of the facts. Now, there are many times where it is apparent that the petition is barred by law. There is an alternate remedy. For example, if you file a petition in the High Court regarding a tender, saying that the government contract was awarded to me, I applied like everybody else for the tender, I participated, but I wasn't selected. That also has an arbitration clause, or also has a clause that says that civil court's jurisdiction is barred. There are also judgments of the Supreme Court which say that tender matters you should not interfere. raise that as a preliminary objection. So normally the petitioner will start first, but if you have a preliminary objection saying that, look, this is barred by law, there is a delay, he has another remedy, he has to go to the civil court, he can't come to the High Court directly, then raise your preliminary objection at the beginning. But if you are a junior, there are times when the judges may not immediately let you may not entertain your preliminary objection at the outset. So what you can do, and this is what I've learned from very eminent lawyers like Mr. Shrihari Ani, who's also from Nagpur. You state your preliminary objection, say that this is my preliminary objection. If you would like me to elaborate on it, I will do it right now or after the petitioner argues. In most cases, at this point of time, the judge will hear you on the preliminary objection. But if you aggressively go and push, and if the judge doesn't want to hear you at the first instance, don't push immediately. Wait for your turn to come and then raise a preliminary objection. Then you have to ask a fundamental question. Does the petitioner have a remedy or no in law? And if the petitioner doesn't have a remedy in law, you put your case saying that it does not have a remedy in law. This petition cannot be maintained. And as I said earlier, that how the High Court, how the Supreme Court has dealt with these cases is extremely important as a respondent. Not to say that as a petitioner you don't have to know, but as a petitioner you still have a little more flexibility. As a respondent, if you are pointed and if your attack is precise, then it solves your purpose. Knowing your justice. I said justice, which would mean judge over here. Now, I don't know whether all of you are following what's happening in the US right now, but there are Senate confirmation hearings going on for the new Supreme Court nominee, President Biden's nominee, who is Judge Ketanji Brown Jackson. I would encourage all of you all to go on to YouTube when you all are done with your updating your Instagram and Facebook profiles or TikTok videos. Spend time also looking at the Senate confirmation hearings and see the kind of questions that the US Senate asks their judges before their appointment is confirmed. Because you will understand that over there, they look at everything the judge does, right from their initial days in college, which societies they were affiliated with in college. For example, she was affiliated with the Black Lawyer Society at Harvard. What she has written, how she has delivered judgments, what her philosophy is. Now, unfortunately, in India, we don't have that system because here we don't have Senate confirmation. The Supreme Court, the High Court or Supreme Court judge is appointed by the president and now through the collegium in concurrence. But if you are going to argue before a judge, please know the background of the judge, whether the judge is pro-petitioner, pro-respondent. If you're new to the bar, you can go back and find out what was the judge. Go to the judge's profile and see, was the judge a government pleader? Was the judge a public prosecutor? Was the judge on several panels? If the judge was on panels, state authority panels, then you know that he's been a respondent lawyer before, he or she has been a respondent lawyer before becoming a judge. Previous judicial background. What is the judge's view on the subject? You have access today to everything right from Manupatra to SEC to live law, bar and bench, Indian Kanun. See how the judge has dealt with this subject. Whether the judge is a technical judge, whether he will go on pleadings, whether they are flexible. Some judges ignore certain lack of averments in a petition and go all out to do justice. Some judges don't do that. And see what previous judgments the judge has delivered. Know your judge, know your justice. It will take you a very long way if you want to win a case. Now, finally, after much effort and mentioning and trying to get the matter listed and trying to convince the judge that there is urgency, finally, if your matter is on board, as a junior, your first thing is that too many thoughts come into your mind. How do I do this? How do I handle this? What do I say? Calm down completely. You don't need to muddle your thoughts. This happens, but you don't need to. The first thing you need to do is ensure that basic compliance is done. Have you served the other party with your petition or reply? Have you filed your affidavit in service? If you are relying on a case law, are you going to give it in advance? Are you going to circulate something? Are you going to submit some pleadings? Are you going to submit some points for argument? These are small things which will take you a very long way. Because if on this ridiculous ground a matter gets adjourned, then you have lost an opportunity. Matters are won and lost on very insignificant issues. Time, and I'm not being philosophical about this, but time and karma go hand in hand. So you have to understand that certain things, whatever is in your control, make sure that you've done everything. Don't go up all ready to argue and then the other side comes and says, no, but he's not even served me the petition. He's not served this on me. I have done this. I'm ready to argue, but I don't have this point. He's not given me the submission. And your entire matter, all your effort unnecessarily goes. So make sure basic compliance is done. Prepare a list of dates, very important. The days of big, glorious arguments are gone. You need to make life easy for the judge. I am not saying that points of law are not argued. Everything is argued. Good points are argued. Good points are made. Law is developed. But make life easy for the judge. Don't make life hard. Spoon feed the judge, because it's not that the judge will not have understood it. The judge doesn't have time anymore. If he has 100 matters on his board, he's not going to have time. Make life easy. Some judges don't want a list of dates. Don't give it to them, but prepare it for yourself if not anything else. And never enter a courtroom just supposing your matter is at serial number 10. Don't enter at 9. Enter the court when it's 3 and 4. See how the judge is dealing with matters. Most matters have some common thread in the entire thing. If you feel that the judge is asking a point on delay or asking counsel in serial number 4, no, but this point is already covered in some judgment. And if supposing that matter is connected to yours, or some way there is some similarity, you are taken by surprise. But at least you have the opportunity to say that, look, this is what happened in serial number 4. My matter is similar. Let me get the judgment, keep it back, pass it over. I'll come and argue it. So make sure you give that flexibility to yourself also. Certain stages of a petition are very important. I've come to this in the latter part of my PPT because I wanted to give you a brief background how to basically argue, but this is important to know also. A matter is filed. It is at the pre-admission stage. At the admission stage, the judge will hear the matter, say for the first time, and issue notice. If you've already served the other side privately, the other side would come there. They will decide them. Earlier, what used to happen is that the judge would admit the matter. Admit means that there is a point in the matter, so we grant rule, which basically means that there is a point in your matter, and we need to hear it finally, a detailed hearing, then final hearing, and then judgment. Now, because of pendency, I would say, and don't take me exactly by what I'm saying percentage-wise, but I would say, in my estimate, about 80 to 90% of all writ petitions today are decided at the stage of admission. A judge doesn't admit it and keep it for final hearing because that stage itself takes 10 to 15 years. So you have at your disposal at least 5 to 10 minutes, and that's a long period of time if you go to see it, to convince the judge about your case. If the judge has already read the brief, you don't need that long. So now judges decide at the stage of admission, means they immediately admit the matter and decide the matter at the outset as well, immediately. Now, if you're arguing a petitioner's brief, summarize your argument in 45 seconds. Time yourself that in 45 seconds I have to put forth what the basic point in the matter is. As I said earlier, if the judge doesn't want a list of dates, please don't give it. Don't give that list of dates and the judge will look at it, put it at the side. The judge wants it, give it. Some judges actually get offended because they've read the brief and come. So you need to know, balance the situation. After you convince the judge that this, after you put your case forward, go to the impugned order. A lot of times what happens is that some people argue the matter, then they go right at the end to the impugned order. because they've read the petition that way. That is a mistake. When you're arguing a petition, put forth your point, take the judge to the order and the challenge, then let the judge ask you your question. Do not deflect a question, answer questions. If you don't know an answer, say you don't know an answer, the judge will respect you. Also, the judge has certain things in his mind, which they want to clear. So if you don't answer that question, the judge is stuck there. You may have moved on, but the judge is stuck on that particular point. So please do not deflect an answer. If you don't know, say you don't know, keep it back, let the judge get angry. But at least today, you are not being dishonest and you're not giving an opportunity for the judge to basically look at you in a different way, in a negative way. A lot of times, sometimes people have this anxiety to directly jump to judgments and case law, saying, no, but I have 10 judgments. You may have 10 judgments, but explain your case. If the judge is in your favor, you don't need to cite authorities, you don't need to cite judgments. And if you are in a division bench, a lot of times, even this is something I do. So what I do is after I argue a matter for the day, I sit back and I think of what mistakes I have made. And this happened to me, in fact, 2 days ago, where I was only looking at the senior judge and not at the junior judge. So the senior judge would sit to your left, which would be his right. And the junior judge would sit to your right, which is his left. So always make sure that today's junior judge is tomorrow's senior judge. So try and at least balance your interactions with both judges as far as possible, even if one judge is controlling the matter. Now, your first hearing, as I said, is exceptionally important. And then in your subsequent hearing or in the same hearing, the respondent starts arguing, understand what the case is, note down the objections. But if the judge is in your favor, don't get up to rejoin. You have the opportunity to rejoin, to counter the respondent. But don't do it if the judge is in your favor. Do not do more than what is required. Do exactly what is required, not more. Now for a respondent brief. We had already spoken about raising a preliminary objection, but it's also very important to listen to the case of the petitioner. Do not interrupt the petitioner all the time because the judge will get irritated, but interject at the right time. If you think that the respondent, if the petitioner is making an absolutely incorrect submission and the judge is buying it, make sure you get up and stop that submission immediately. Sense the mood. If the judge is already against the petitioner, don't get up and do too much. Sit down. This is like what happens today. Supposing there are in your home, if you're a 2 or 3 siblings, and if one sibling is blasted and yelled at, if the other one tries to intervene, then both siblings are hit up. So remember that when one person is, if the judge is not against, if judge is against the petitioner, don't get up and say anything. Anticipate the questions now based on what the petitioner's case is, and then attempt to change the mind of the judge. Try and swinging the case is very important for the respondent, because if the petitioner has a very good case, then you have to swing it. Then you have to say that, look, if the petitioner's case is good, say that I don't doubt what he's saying, but could we look at it this way? Try and look at a mid-level compromise formula so that you can get the best order possible, even if the petitioner wins. The most important thing, which I have also partly covered, is knowing when to keep shut. It is important knowing when to keep. Matters are won for the respondent only on silence. And if you don't, if you get up and you get aggressive and you try and argue something beyond a particular point, then the judge is going to, in fact, allow the petition completely. Distinguishing case law cited by petitioners. Now, very important point. Sometimes 3 judgments are put forward immediately by the petitioner. You don't have time to read everything. But before you do argue a matter for the respondent, anticipate that these are the judgments which will come up, and get judgments to say that, look, he cited this, these are the facts in that matter, but the facts in our matter is completely different. And as I mentioned, looking for a compromise formula as a respondent is very important. Now, I don't know exactly whether a lot of these matters come up in Nagpur, but particularly in Mumbai, Pune, that belt, there are a lot of builder matters. For example, MOFA matters. Now, there is a clause in the ownership of flats act which talks about deemed conveyance, that if the builder doesn't convey the land, society can ask for deemed conveyance. Most case times, judges are against builders. Judges don't like builders. You have to come up and put forth a compromise formula saying that, okay, this is the problem, this is the situation, I understand this is what I have to do, or this is what I do not have to do. Approach it with a middle ground formula. Don't go and be a crusader for a respondent who has already somewhere down the line that he's at fault. Look at a compromise formula, it will save your client. And lastly, this is a very important point. When the judge is dictating the order, if there is an error, if it can be looked over, don't interrupt the judge. If it is a blatant error where he says that there are 12 buildings instead of saying that there are 15 buildings, then please interrupt immediately. Or you can wait till the entire judgment is pronounced, and then thereafter you can perhaps tell the judge that this is the issue. And if you are a petitioner, if you already have an interim stay order and your client wants to go to the Supreme Court against that judgment, then please ask for extension of your interim order for a period of 2 weeks or 4 weeks. A lot of juniors forget to do this. So this is very important. The petition will be dismissed at the request of learned counsel for the petitioner. Extension of the stay order, or the stay order is continued for a period of 4 weeks in order to enable the petitioner to pursue alternate remedies. So make sure you ask for your extension if you have interim relief. And speak to your opposing counsel after the matter is over. Some lawyers take matters very personally. I'm not one of those lawyers. I'm emotionally detached from a matter. It helps my client more than it helps me. But speak to your opposing counsel, say that this point is very good. If your opposing counsel is a senior, ask the senior, should I have done something more? Should I have argued something more? The senior will actually, even if it's an opposing counsel, tell you or give you tips which will be very, very useful for you. So having said that, these are my nuggets on how a matter should be argued or it should be argued. I am open to questions. If there's anything, please ask.
Sir, one question is, please guide the lawyers who have fear to argue in High Court only due to language barriers.
See, I'll tell you what. This is a very important problem. It is actually a very relevant issue. I honestly feel that the language barrier is only in your mind, because there are a lot of times now that most of the documents are in Marathi. Now, until you keep trying and until you keep talking, until you keep speaking, you're not going to get over it. What I would suggest to you is that this is what my senior suggested, that you have voice recording on your phone, argue an entire matter in front of the mirror and listen to yourself, and you will realize what the mistakes are, and keep doing that over and over again, and you will realize that you will improve on your own. The language barrier is in your head, it is in your mind, and until you get over that in your mind, you will not be able to progress. There are hundreds of examples where people have passed out from vernacular schools and today are sitting in the Supreme Court. So, but this arguing in front of the mirror or listening to your own voice will help you in the long run.
Thank you, sir. So next question is, many petitions not allow on ground of technical. How to save?
Very difficult to answer because it depends on the judge. As I told you, a Nagpur judge loves technicality. A Bombay judge would be more liberal. So it all depends. If you are for the petitioner, then you need to draft it in such a way. For example, I'll tell you what. You all know your writ of mandamus. Basically, it's a command or direction. Now, there is a practice to make a representation. For example, if the government is not passing an order in your favor or not deciding a point, you send a letter to the government saying that, please decide this. A lot of times, lawyers don't advise their clients to do that. And a Nagpur judge would immediately dismiss it on that ground, saying that you've not written a letter. Okay. To save yourself on technicalities, what you could request as a junior, saying that, look, this is, I am still junior, let the judge yell and scream. You treat my writ petition, which I filed, as a representation to the government and tell them to take action. Convert it that way. This is just one example. It all depends. If you have a technical judge, then perhaps it will be important not to push the matter before that judge and wait for a judge who is a little more liberal. Courtcraft is very important.
Thank you, sir. Sir, you told to focus on reading impugnant order. So, but in case of read,
Yeah. Sorry, I interrupted. Tell me.
no. In case of read, is there impugnant order? Perhaps High Court exercises its original jurisdiction rather than appellate. Please clarify it.
No, I didn't answer. Understand your question.
You told to focus on reading impugnant orders. But
No,
in
I
case of
said that as a respondent, you focus on reading the impugned order first. As a petitioner, you are challenging that order. So the original jurisdiction of the High Court is not exercised in that sense in any other bench except the Bombay bench, the principal bench. So the original jurisdiction will only depend on territorial jurisdiction. So when an order is impugned, you file a petition under Article 226 where you ask for a direction from the court or a writ. So it's perfectly maintainable. If I've understood your question, if that is the question you're asking me.
Yes, yes, sir, absolutely, sir. Sir, can a writ petition be made for public interest even without locus standi?
The concept of public interest, which is developed right from the Krishnayar courts to Bhagwati courts, are meant for that. But nowadays, what's happening is because most petitions, PILs, are politically motivated. We have, if you just go on to the Bombay High Court rules, there are public interest litigation rules of 2010, where there's an entire format on how to draft a PIL. So definitely, if you are a public-spirited person who has no vested interest, then a PIL is certainly maintainable.
Yes, sir. Sir, can other judgments can be referred in Bombay High Court other than Bombay High Court judgments? As
The
per your
Bombay,
experience?
correct. So each High Court has jurisdiction only in their own state. The extended jurisdiction is only up to their state. However, the judge of a judgment of another High Court is not binding on one High Court. If that judgment appeals to the, I'll tell you how this works. Supposing there are two judgments, view taken by Bombay High Court, view taken by Madras High Court. Bombay High Court obviously prevails. You're not bound by Madras High Court. Look at the second situation where no judgment given by Bombay High Court, judgment given by Madras High Court. A judge is not bound by that, but definitely can use that as persuasive value and agree with the view taken by the Madras High Court or disagree with the view taken by the Madras High Court. But there is a third thing which has developed now. If today, this happened in the 97th Amendment by the Gujarat High Court, Justice Pardiwala delivered a judgment, where they struck down the 97th Amendment. Now, the law developed by the Supreme Court is this, that if today one High Court says strikes down a particular amendment, a constitutional amendment, that view of the High Court or that judgment is binding on all courts if no judgment is gained by the Supreme Court or no contrary view is taken by another court. This also happened in the Nas Foundation matter when Justice Ajit Shah struck down 377 or read it down before it went to the Supreme Court. So that is the third view which is now recently developed in the last 10 to 20 years.
Yes, sir. Sir, can a layman prepare its own writ petition and file before the court without taking help of lawyers?
Yes, 100% a layman can do that. For example, if you go to a doctor, you have a choice of going to a doctor or self-medicating. I am one of the people who self-medicates and prescribe medicines illegally, so I should be arrested also. But as a layman, you have every right to do it, and you just need permission from the High Court under the rule making provisions. My personal view is that that provision is absolutely unconstitutional. That's my personal view. I am no one. If it has to be challenged in an appropriate manner, it will be challenged. But now the High Court has developed something called the rule making, something called a procedure where permission of the registrar is required to appear in person. In most cases, permission is granted. But I am of the view that if a party wants to argue in person, you cannot insist that he should have a lawyer.
Thank you, sir. Sir, without going into merits of the case, can court grant reliefs which is not prayed in the petition?
No, not at all. A court cannot go beyond the prayer clause. It goes to the Supreme Court. Supreme Court will set aside that judgment. What judges do sometimes is that they give you leave to amend. You amend your petition, you add the prayer clause. For example, in 2014, we had the new Land Acquisition Act which came in. Okay. One of the issues was lapsing of acquisitions under the old act by way of Section 24(2). A lot of people then filed applications for amendment to amend their existing petition so they could take that ground. Some judges allowed it, some judges didn't. So the answer is to your question is no, but leave to amend can be requested for amend the petition, and you can definitely get what you want if your case is good.
Yes, sir. So the last question is whether a High Court can pass orders which would have effect beyond its territorial jurisdiction is an issue that has something of the history.
Right. So we started in the 1950s with the Chamarbagwala judgment, where you had extraterritorial operation of legislation. This is if I have to answer this question, I will need another 2 hours to answer this question. But the answer is that the jurisdiction of the High Court doesn't go beyond a particular state. But if the cause of action to some extent, or if the occurrence has happened within a particular state, then to some extent extraterritorial operation can apply. But again, it is very subjective, depends on various facts, and this is a discussion, in fact, which will take quite some time. So I would like to come to Nagpur and have that discussion.
Sure, sir.
Yeah.
Sir, really, thank you so much, sir, for helping us become more aware of the problems and the ways we can help to solve them. And for today's new generation advocates required more motivation as they are not having any kind of experiences before and no other person to guide them, to help them to get motivated and go long run for this profession. So thank you so much, sir.
Thank you. I've given my LinkedIn details. Whoever wants to reach out, students can reach out to me. There's no problem.
Yes, sir. Sir, so now request Mr. Tariq Khan, sir, to give the formal vote of thanks.
Respected Advocate Dorman Dalal Sir, Bombay High Court, Mumbai, Dr. Payal Thaure Madam, HOD Postgraduate Teaching Department of Law, RTM Nagpur University, faculty members, my colleagues, and dear participants, a very good morning to all. I, Tariq Khan, on behalf of Postgraduate Teaching Department of Law, express my deep sense of gratitude towards you, sir, for sharing your knowledge and experiences of practicing in High Court would definitely be helpful to the participants. We are thankful to you for sparing your valuable time for this event. I am thankful to our own HOD, Dr. Payal Thaure Ma'am, HOD Department of Law. It is only because of your positive encouragement, Madam, we were able to successfully organize this webinar. In addition to this, I am also thankful to our technical team who arranged and provided complete technical support and assistance for organizing this webinar. All the volunteers involved in the webinar deserve special mention and thanks too. I would like to express my thanks to all participants for joining this webinar. Thank you, one and all, for your support in making this webinar a success. Thank you once again.
Thank you.
This message is for all. Please note, feedback link has been posted in the chat box. Kindly fill it.
Thank you
Over
so
to
much,
you,
sir.
ma'am.
Thank you so much, sir.
Thank you so much for inviting me.
Thank you, Dorman.
Thank you.
Thank you so much. It was indeed an enlightening lecture. Thank you so much.
I hope to come to
And,
Nagpur and do this now.
The video of this lecture will be available